Welcome to Court Helicopter News. Our explainer, which is the last explainer that deals with the law of succession. Today we are looking at how do you now move to court? How do you move to court? And which courts are available? The first one, after the death of somebody, the first document that you need to have is a letter from the chief. The letter from the chief will identify who the beneficiaries are, and that is the spouse, living and dead, and the children of the deceased, living and dead. If there were 5 spouses, the chief will have to put that. The second document you will move to is the death certificate. You either go to an advocate to start the process, or you yourself, you can move to court and file succession application forms in the court. The second stage is now which courts can you go to for succession. There are specialized courts for that. One, the magistrate's court has jurisdiction to do succession. The High Court has jurisdiction to do the High Court, to do succession. How do you go to court? You will go to court. The first thing that you'll go to court is to seek for limited letters of grant. These are letters that will allow you to start preserving the property, to start moving to file a succession matter in court. The court, after hearing both parties, the court will demand all the spouses and all the children to come to court. They will be heard. There will be affidavits. After they have been heard, this message will be sent to the government printer. The government printer prints every succession matter in this country. So, if somebody died in Nyamira, or in Garissa, or Wajir, or Meru, the law of succession demands that a gazette notice must be done in the Kenya Gazette to notify the whole public. So if your father died and somebody went and did succession without knowing, by the Kenya Gazette, check were there. After the Kenya Gazette, confirmation of the grant is brought to court. The members, the beneficiaries must all come to court to confirm that they have agreed the mode of distribution. Then the court will confirm a grant. Only after confirmation of the grant will the property move from the deceased to the people that were brought to court as the ones who are going to be distributed to the property of the deceased person. All the properties must be brought to court, and the court orders the land registrar or so and so now out of the grant to transfer the property from the deceased to the beneficiaries that are there. After this, sometimes people might go to court. Later, they discover that there are some properties that were not captured. You'll still move to court and ask the court to include the properties that have been discovered later in the grant, and the grant shall be done to that effect to reflect the properties that were not there. Now, the fourth issue is some people rush to court without telling the other members of the family. They get letters of grant and they start distributing the property, or they sell the properties. Later, the beneficiaries come to learn that succession was done. Don't cry. You will go to court and file an application called objector proceedings. You are objecting to the court that the court, you were misled to give this property to so and so. We are the rightful children, or we were excluded from this, or we were minor children by the time they were doing the estate. Projector proceedings if it will succeed, will revoke the grant that was given. Whatever grant that was given, if it was obtained by material non-disclosure, that the person who went to court did not disclose in totality the true facts, the grant will be revoked. 2, if the grant was obtained fraudulently, the court will nullify that grant. And lastly, if the grant was granted by court by false misrepresentation, that grant will be revoked. The third aspect is, for example, you have a father, before he died, had entered into a sale agreement with some people to sell land. He dies before the transaction is complete. That transaction remains an abeyance until succession is done. Those who bought this land cannot get a title deed. They go to the wife says, I'm not interested. They go to the children, the children say they don't want to go to court. You, as the person who bought land, you as the person who had bought a vehicle from the deceased, but he had not succeeded to transfer, you can move to court and make an application, what is called an application to cite those people, where you are saying, me, Omari, I bought land from Kinyanjui who has died. The wife and the children have refused to go to court. Allow me to file succession on my behalf. If they will not, they will be summoned to come to court, and they will be given by the court timelines to either file succession within 30 days, 40 days, 60 days, failure to which the court will allow Omari, who bought land, to file that succession. That is what we call an application for succession. Then we have a person who has been appointed as a personal representative, as a trustee. The land might be transferred to him, and this person thinks the land is his. The executors, those people who have been given to execute the will, are stealing the property and turning the land into that. It is a crime, a criminal offense, if you are a personal representative, or if you are an executor, if you are an administrator, to allocate yourself properties that are not yours. Lastly, there is this thing we call Section 96 of the Law of Succession Act. It's very critical. People know their father has drafted a will, and in the will, he has allocated properties to them. But the father is refusing to die. He did a will when he was 40, he's 50, he's 60, he's 70, he's 90. He's not dying. And you are a beneficiary of that will. You plan with the mother, you kill the father, so that you inherit the properties of the will. Section 96 is clear. If you kill somebody for the purpose of you to inherit, and that is produced in court, you will not inherit that property. Anybody who will commit murder for the purpose of inheriting the property of a deceased person who you have killed, you will not get anything. And lastly, when the property is being distributed, the first thing to be paid are their taxes and debts. So you might see an estate of 10 billion shillings, but the taxes are 4 billion and the debts are 11 billion shillings. You will not inherit anything. The first priority is the Kenya Revenue Authority and the debts. Then it is the net residue that remains that you will be given. What is my advice? Look for your property. You might be thinking your father has enough. When he dies, you will inherit. Your mother has enough. If she dies, you will inherit. or your father can live until you die earlier than him. Court Helicopter News, that marks the end of the law of succession. My advice, do not sit on land. Do not use the property of your parents until you have letters of confirmation from a competent court of law. The wazees at home, the jurinjeke, cannot give you the property of a dead person. Wakili Danstan Omari. See you next week when we shall be dealing on other matters. Thank you very much.